Thank you, Mr. Bisbee. This will now call to order the Human Services Background Study Eligibility Task Force. Mr. Vogel, can you please do a roll call?
Certainly, Mr. Chair. Ms. Basham?
I am here. Thank you.
Thank you. Senator Champion? Senator Champion. Ms. Dawson? Ms. Dawson. Mr. Esme?
Present.
Ms. Evans?
Here.
Mr. Geffen?
Present.
Mr. Hanson?
Present.
Ms. Huntley? Ms. Huntley? Mr. Urban?
Present.
Oh, thank you. Ms. Kaser?
Present.
Mr. Kammer?
Present.
Lieutenant Knotts? Lieutenant Knotts? Judge Kulik? Judge Kulik? Senator Matthews? Senator Matthews? Ms. Mattson? Ms. Mattson? Representative Mueller?
Present.
Thank you. Inspector General Modi?
Present.
Mr. Page? Mr. Page? Ms. Robertus?
Good morning.
Morning. Representative Robbins?
Present.
Thank you.
Present.
Thank you, Representative. Mr. Sandoval? Mr. Sandoval? Judge Satterback? Judge Satterback? Ms. Sherlock?
Present.
Mr. Tatum? Mr. Tatum? Ms. Williamson?
Present.
Thank you. Mr. Chair, 14 of the 25 members are present. A quorum is present.
Thank you so much, Mr. Vogel. And Mr. Vogel has also posted a copy of the October 21st meeting minutes on the task force website. And now we will open it up for any corrections, additions, or issues of any type with those meeting minutes. Seeing no hands raised or hearing any voices, we're going to adopt those meeting minutes as posted. Thank you. So moving forward, what we're going to do today is go over recommendations from both the disqualification task force and the remedies task force subcommittee, excuse me. And, you know, if people have any concerns, objections, this would be a good time to sort of go over it. We're not going to do a vote on anything today. If there are major issues, we can come back with additional language, discuss issues with those recommendations as to what the subcommittee thought as to the why and the how and anything else. We're also going to set forth today a pretty good plan moving forward with Mr. Vogel's guidance on what are our next steps, including voting. Certainly, the Department of Human Services needs to weigh in on this, and we're setting up that meeting as well. Before we dive into some of the specifics with the recommendations and opening it up for discussion, are there any issues that anybody has in the task force before we move forward? All right, let's dig in. Mr. Vogel, would it be possible for you to put the bullet points from the disqualification subcommittee up? Thank you, Mr. Vogel. So we're going to go through this, but you know, I'm a member of the disqualification subcommittee, but it would invite anybody else on the disqualification subcommittee to please weigh in on anything that I'm missing. I'm going to try not to read this document. Has everybody, well, I should ask, does anybody need a copy of this document that doesn't have it? Mr. Vogel, I don't see any hands raised, but if you do, would you mind sending it to those individuals? And for some reason, I'm not seeing the first page of the document.
Yeah, that's a technical issue, Mr. Chair. I'm trying to resolve that right now.
Okay.
Apologies.
Maybe I'll give a little bit of background that I don't think matters too much. There it is. So the five things that the disqualification subcommittee narrowed its review down to was the list of disqualifying offenses, the length of the disqualification for those offenses, the date a disqualification period should begin, how juvenile matters should be addressed by the disqualification statute, and had a discussion on child foster care as it relates to background studies. We're going to focus now on juvenile offenses. And, under the current law, the Department of Human Services looks at juvenile offenses when making a determination whether to disqualify. And as we know, juvenile offenses are not criminal offenses. They're defined as juvenile adjudications and are treated differently in our criminal justice system. They're not criminal offenses by definition and statute. They're juvenile cases and are treated very differently. However, under the background study, juvenile adjudications are treated very similar to the way that an adult conviction would be dealt with. So if you had a 14-year-old who was adjudicated for burglary at a felony level, they would be disqualified for 15 years, the same as the adult committing the offense. So one of the things that was concerning to the disqualification subcommittee was brain science, maturity, and that high impulsivity and other issues identified by science has sort of enlightened us that children make some stupid mistakes. And it doesn't have always a bearing on whether or not they're going to be a person who poses a risk of harm to individuals. And that they grow up, their brain develops, and they make better decisions. We also looked at some of the concerning racial disparities in the juvenile court system. And in Hennepin County, I think this data was provided to us or given to us or pointed out to us by individuals in the remedies subcommittee. 66.5% of juvenile prosecutions involve people identified as Black or African American, while only 19.89% identify as white. And so we have significant disparity in who's going through the juvenile court system. And obviously, as you move further down, if you have these juvenile adjudications and they have bearing on an individual's ability to find work, it has a disproportionate impact on employment. And the other thing we recognize is that there are some people who are involved in juvenile matters that are very serious and should not be providing services to vulnerable individuals, whether they be children or adults. So what we ended up on our recommendation was to continue permanent disqualification of juveniles certified as adults and prosecuted as adults. Continue to permit disqualifications of individuals who are certified as adults and prosecuted as adults. So as we know in our system, certain individuals that commit serious crimes as juveniles will be certified as adults. So our recommendations do not involve those individuals. The only individuals that our recommendation involves are juveniles that stay within the juvenile system who are not certified as adults. And the recommendation was that individuals who are adjudicated delinquent, and I'll get you just in a second, Josh, who are adjudicated delinquent under the juvenile court system, not certified as adult, have a 5-year disqualification period. The 5-year disqualification period will be the date of conviction if the individual was convicted of the violation but not committed to the custody of anybody in corrections. So if the person has an offense where they're staying in the community, it's a 5-year. However, if it's a more severe one, and that person goes to some type of juvenile facility, that individual waiting period of 5 years won't begin until they are released from the Department of Corrections. And finally, some individuals could continue to pursue a set aside, of course, of that 5-year. Want to highlight a couple things. One is any subsequent offense retolls the 5 years. So if juveniles are making bad decisions more than once, then that period of 5 years is extended by the new offenses. If they commit offenses as adults, those are used too. So this will help individuals who make bad decisions at a very young age and then have extended period where they're not making mistakes. We want to identify that there are some members that believe juvenile cases, some members of the subcommittee believed that juveniles should be treated the same as adults. And some others believe that juvenile records should never be used. But that is the recommendation. Mr. Esme, please.
Thank you, Mr. Chair. So actually just two questions about the summary. On the point that you were just talking about subsequent offenses tolling the DQ period, is that any offense or does it also have to be a subsequent disqualifying offense?
Subsequent disqualifying offense.
Okay.
So if you're a juvenile and you were engaged in some activity that was not a disqualifying offense, it would have no bearing on a disqualification.
Okay, and then
So
the other question I had was just a clarification under point 3A here. Continuing to permit disqualifications for juveniles certified as adults. Did the subcommittee think about how that would interact with the extended juvenile jurisdiction process?
Yes, we had identified that individuals who participate in the EJJ process would still remain in the juvenile court system and would still remain as an individual who would be disqualified for 5 years.
Is that the case even if they don't successfully complete EJJ?
If they don't successfully complete EJJ, they would then have an adult criminal sentence, which would then move them to the adult.
It would,
provisions.
okay. I assumed that was the case. It just wasn't quite clear from the bullet point there. So thank you for clarifying.
And I would admit it needs to be more clear. And I think, Mr. Vogel, if you'd make a note that we need to explain the EJJ provision and have a discussion about to make sure we're all on the same page. And for those individuals who participate in EJJ and do not complete and an adult sentence is levied, that person would then not benefit from this. It would be an adult case. Representative Moeller, please, and thank you.
Yeah, thanks. I had a question about 3C. It says the date of conviction. Is this the date of adjudication?
Yes.
Okay, sorry. I was a little confused since juveniles
No.
are adjudicated and not actually convicted.
I appreciate you pointing that out. I think we cut and pasted it from another section.
Gotcha. Okay.
But you're right. As I go through a great spiel about how they're not convictions, I use the word conviction.
Well, yeah, and I
Thank
wasn't
you.
trying to be picky. I thought I truly was like not understanding something, so just wanted to make sure.
No, I appreciate it. Other questions, concerns about this recommendation? And certainly this isn't your only time to discuss it. We can discuss it any time you choose. We'll go now to the second issue. And we looked at length of disqualification. As we know, after having many discussions, our current system breaks into essentially 4 tiers: 7-year disqualification, 10-year disqualification, 15-year disqualification, and a permanent disqualification. And some of the concerns of those bright line levels were really inconsistent with other states. We have much longer disqualification periods, and that leads to think that these seem to be longer than are necessary to maintain safety of those individuals these people want to serve. And constantly coming back to the issue that this statute is not punitive. This is just designed to make sure that people are protected who are vulnerable, and that there's a criminal sentence, people deal with their sentence, but are individuals safe to return to the workforce? They're not having issues for extended periods of time. We also identified that we have significant racial disparities within these issues as well. I won't go through them all. They're in this document, but I think they are important to understand. We also note that there's currently a 15-year disqualification for individuals with drug possession, which is inconsistent with public safety. Disqualification periods seem to be much longer than individuals. If people are going through extended periods where they're not using, where they're having success in their community, where they're not having additional convictions, they're doing well. And a 15-year disqualification, and let's say it's a felony with a 5-year probationary period, is really a 20-year disqualification from doing work. We did note that the 2008 task force made the same recommendation, that this is too long for this and doesn't make Doesn't make sense. So the other issue is currently, the current law has the exact same disqualification period for 5th degree controlled substance, which is a possession level, and a 1st degree controlled substance, which is a sales level. And that the law treats someone who is dealing with some addiction the same as somebody who might be selling, and it didn't make sense. These long periods, 15-year disqualification exceeds significantly the Adam Walsh requirement, which I think would have these at 5-year disqualifications. And it's also inconsistent with the criminal expungement statute. The legislature redid the criminal expungement statute that went into effect in 2015 and identifies that individuals can seek expungement much earlier than these long disqualification periods. So for diversions or stay of adjudications, 1 year, misdemeanor convictions, 2 years, gross misdemeanor, 3 years, and felonies, 5 years. And that's after completion of sentence. So we have a really significant disparity. One of the concerns there is that it has historically been that individuals with financial means can get things expunged, while other people who might come from less affluence don't have those means to do it. There are a lot of agencies that try to reduce this disparity, but it is pretty accurate. University of Michigan did a study a few years ago identifying that expungement is almost uniformly underused in poorer communities, leading to lower rates of seeking expungement and lower rates of success and lower access to jobs. Our recommendation is to remove the current structure of the 7, 10, 15 permanent disqualification and replace it with a 2-tier system, which is essentially mirroring the Adam Walsh Act, which is a 5-year disqualification and a permanent disqualification. 2 buckets, simple, and a way to ensure that people who are currently making mistakes are not having access to individuals who are vulnerable, but not over punishing beyond a person's safety issue. Again, we would note that we didn't have uniformity and consensus for everyone, and that some members believe the current structure of 7, 10, 15 permit is sufficient, and that our focus should shift to shortening the processing times for set-asides and other remedies. I'd like to open that up to discussion for the group. Okay, seeing no hands, I'm going to go to the list of disqualifying offenses. As everybody knows, the way the statute's written now is not every crime is a disqualifying offense. So if you have a disorderly conduct, disorderly conduct is not a disqualifying offense. Jaywalking, not a disqualifying offense. But the concern was that of the list of disqualifying offenses, there are a fair amount of them that don't have a relationship to safety. That there are times where the crimes exist and they're mistakes, but they might be more crimes of poverty, crimes of impulsivity, but not an indication that somebody is a bad person and unfit to work with certain individuals. It also, one of the things that we really want to highlight on this is the unique nature of the background study law is it disqualifies individuals. It's a government decision to disqualify individuals and removes the employer from making some of these decisions. So, you know, if I have a misdemeanor for theft and I apply at Target gets to vet me out and make a decision whether they think I'm a good fit for their organization, and they can hire me or not, but Target makes the decision. In the disqualification realm, if an individual has a background that disqualifies them, the employer can't hire them. In fact, it's a crime to hire them. We had testimony from individuals at Adult and Teen Challenge identifying they had people they had worked with for a long time, people that had gone through their program that they wanted to hire. And it came back that the individual was disqualified and couldn't get a set aside. So they were, despite what they thought was in the best interest of their organization, a government entity said they can't do it. So the goal of some of the listed disqualifying offenses is not to make them unavailable, but to at least limit employer make some decisions on who they want to hire. And so that's the overview a little bit of why we're doing it. Again, we are inconsistent with other states. The list that we have is robust. Other states don't include nearly as many. Many federal laws, the Adam Walsh Act and certain block grants don't include all of these offenses. We noticed too, through input from individuals that have been part of the changes to the child foster care laws, that many of the offenses that were removed from the list of disqualifications from child foster care cases are still in the general statute. So we're recommending removal of some specific offenses. And these first group would be to remove the misdemeanor, gross misdemeanor offenses. And these were designed to be the ones that we did not think had direct impact on safety of vulnerable individuals. Again, the employer still gets to make the decision, but wrongfully obtaining public assistance, unemployment fraud, federal SNAP benefit fraud, medical assistance fraud, misdemeanor, gross misdemeanor theft, bringing stolen goods into Minnesota, issuance of a dishonored check, and financial transaction fraud. Those are the ones we sought or recommended to eliminate. And I'll go to the next part here and we'll look at the ones that we thought reducing from 15-year disqualifications to 5-year disqualifications. Included, again, wrongfully receiving public assistance, unemployment fraud, federal SNAP fraud, MA fraud, possession of shoplifting gear, bringing stolen goods into Minnesota, issuance of a dishonored check, possession of burglary tools, insurance fraud, aggravated forgery, check forgery, offering a forged check, fraud in obtaining credit, financial transaction, card fraud, and the drug cases. The drug cases under 152. And the goal there was that when we see individuals who are in recovery and doing well, that should be a 5-year disqualification, not 15. Again, employers get to review these records. Employers get to make decisions, and applicants get to explain the situation to employers, and it shifts some of that burden to employers to make decisions. Any questions, thoughts, comments on the recommendations first regarding the list of disqualifying?
Chair Geffen, this is Roy Kammer. So I wasn't part of this committee, and I'm curious, do we understand the history of why we have so much more listed in Minnesota? Could you help explain that to me so I can be on in the know?
No, I won't. I don't think we know. And I would open it up to anyone who has thoughts on this. I don't think we really fully understand it. There certainly has never been a thoughtful document that we've seen that says we created the 7, 10, 15-year model because of this. The way our 7, 10, 15-year model works is a little bit because it goes misdemeanor, gross misdemeanor, felony. That's the majority of it. Are there others in the group that have more insight to answer Professor Kammer's question?
Mr. Chair, as a really high level, thumbnail overview of what I understand the legislative history, the look back structure, the 15-10-7 dates from the mid-late 1990s. It's sort of a rationalization move for background studies. As I understand it, there were some inconsistencies depending on the job at the time. And then, so as a thumbnail, in the 90s, this structure is developed, and there was something of a proliferation of disqualifying crimes in the aughts, especially around 2005, that this structure already existed. So those were applied to that existing structure. So it's again, it's a really high level overview. It appears this was sort of an organic growth over time of this interaction of the look back structure and the list of disqualifying crimes. I hope that helps. Yeah, I'm not being very specific there.
One of the things I feel that this report doesn't do a very good job of is focus on the needs of the community in a lot of these settings. Specifically, we are in a time of significant workforce shortages. And workforce shortages on the business side are terrible, but they're also a terrible thing for individuals who are in need of services. We are talking about people that need care. And we received and had presentations from organizations that are desperate to hire people and want the opportunity to hire who they deem to be safe providers of care. So I think that it's a changes that will help employers, will help people seeking jobs, and will help people receiving services because they're underserved at this time. We should include more on that, Mr. Vogel. One of the other issues we talked about was when should the disqualification period begin? Currently, disqualifications are, I break it down a bit, but let's talk about with convictions. Convictions under the current law, your disqualification period begins at the date you complete your sentence. This can be really difficult, especially for older cases where people have really long probationary periods. So if you had a drug case with a 10-year probationary period, your disqualification is 25 years. And while some people with shorter probationary periods, it's less. But if you have a 5-year probationary period currently, which is pretty consistent with a lot of felonies, you're going to end up with essentially a 20-year disqualification period. I break this down a little bit more. It's a little bit different for preponderance of evidence, Alpert plea, but it leads to really the group's concerns, or it leads to some unfair and unequal results. It's not really based on your conduct, whether you get a 10-year probationary period or a 2-year probationary period. Judge Kulik, who sits on our subcommittee, talked a lot about COVID and how COVID delayed hearings, people just asserting their rights to have, their case heard. And that if you had a 3-year delay there with no subsequent issues in your disqualification period, you've really added 4 years to your disqualification. It also punishes people. It punishes people who want to assert a right to a criminal trial. And that's a constitutional right. An individual has that right, but under our current statute, if you assert that right, you've increased your probationary period, your disqualification period significantly. It's also inconsistent with the new child foster care rules. Under the new child foster care rules, which is essentially our recommendation, is that we look at the date of the incident, the date of the conduct that causes the concern. And it goes into 2 tiers, date of incident, and then the other part would be if you are sent to if you're sent to corrections, the date you get out of prison. So the more serious offenses, you're going to have a longer disqualification. Sentences without the longer ones that you just have probationary period, you're not in corrections, you go to the date of incident. We had a lot of discussion about this, and I'll get to Mr. Esme and Ms. Mullen in just a second. Some members believed keeping the date of release from supervision made the most sense, that this was based on the idea that a time that a person is crime-free really begins the date supervision ends. That's when we have taken off the proverbial training wheels. Mr. Esme, please.
Thank you, Mr. Chair. I just wanted to just briefly elaborate on one of the bullet points about the probation length, not being based on conduct, just from the perspective of a, practitioner, I guess, in the criminal justice system. One of the things that historically sort of how we see this play out is judges don't often set the probation lengths by, digging into the specific facts of the case. It's much more often just sort of based on how it's done in that judicial district, and has historically led to some pretty big disparities, like across the state, where some parts of the state will use really long probation sentences for certain types of crimes just as a matter of course, and others don't. And so I think that's an important factor, and I would just echo the concern.
Thank you so much. And that was raised in our subcommittee, and the other issue was early release. So some jurisdictions do not permit early release from probations while others routinely do, which leads to some further discrepancies that don't probably have any bearing on safety. Representative Moeller, please.
Yeah, thanks. I'm just trying to think of practically how this would play out. And I can see situations where somebody commits an offense. So the clock, let's say a 5-year clock starts to run. Under the statute of limitations, they're not charged for a while for whatever reasons, investigation is still ongoing. Then by the time they get a conviction, their period's already run. So if they're not going to be incarcerated, their period, and they could have jail time, but as far as being sent to DOC facility, their time period will already be over by the time they even get that conviction. Did you all discuss that kind of scenario at all?
We did. So one of the issues, of course, is, you know, we still have a list, you know, of cases that might involve permanent disqualifications. And if that list exists, consistent with Adam Walsh, then those people don't, like those more serious offenses aren't going to slip in there. Because, you know, they're when the disqualification begins doesn't matter. And, you know, the discussion was trying to find, I think there were imperfect things with every one we came up with. And the focus, and I think Judge Kulib drove us on this a lot too, was you're concerned with the conduct. The date of the conduct is what the date of the mistake. We're looking at that as the moment of you erred. And if you've gone an extended period where you haven't made those mistakes, that should be consistent enough to it. Is anybody else, and I'm not doing a great job articulating this, anyone else from the subcommittee want to weigh in on that discussion? Because truthfully, we struggled with this.
Yep. And I think the other part of it is like just from the perspective of somebody that continued to mess up, and that tends to be the pattern until someone stops screwing up, is that's what happens, right? That time clock just continues to start over and start over and start over until it doesn't, right? And that's what the person from Harvard came in and said. That's what the guy from Children's Mental Health came in and said, that there's this point, which tended to continue to be 5 years, that people kind of get it together, and then that those incidents stop happening. And so it's like you can just count on people to continue to have that pattern in their life, and that time frame continues to start over and start over until it doesn't. And so
Gina, can I ask a question about that
Yeah.
too? Is that 5 years, you know, is that from the time when someone's held accountable? Like, I know I hear a lot about the 5 years too, as being sort of for people being on probation. Like, we really know that within that 5-year period, if they're not offending again, then why give them 20 years of probation, right? Because we have data on that. But what's the 5-year date starting at?
Yep. So the two different times that we kind of looked at for people that came in and talked to us were about sobriety dates. And then the other one, like, you know, it was really hard to pin down. And so like the date that we looked at was about behavior, right? Because that's what we're talking about here for employment, right? We want to know, like, from the behavior that we don't want to see again, which was like the incident, the harmful incident that happened, and that, you know, was the date of incident, right? And so if that person committed that incident and then, you know, went through court and all that stuff, and has not committed an incident like that again through their probationary period and for 5 years, and hasn't committed any additional incidents like that, then an employer can look at them for these types of employment. If that person went to prison and was held accountable in the prison system, then that time period doesn't start until they're released from prison, because who can't behave themselves in prison, right? And so all the other dates, conviction, all that, they're so fluid, like depending on if you got an attorney, depending on if it was a, you know, like how the courts are acting based on volume. And so, because that's the thing we're looking at, is the behavior, right? We want to get that person away from the behavior itself. And so it, like, I vacillated on it. And after hearing from some folks, it really does make sense to me.
You know, the other thing I wanted to add, Representative Moeller, is the language in this one is actually what exists right now in the licensed family foster care rules or law that changed recently. We just essentially mirrored it. So under the, to determine if a family is eligible to be a foster parent, this was the language, the look back period. And we just, I wish Max were here. We kind of copied it. But Ms. Kaser, Ms. Sherlock, you were a part a little bit more in that process and the foster care setting. Any thoughts you have on that?
I think the only thing I would add is, certainly that information, again, is provided to whomever, an employer, or in our situation, when we're licensing someone, that information is provided to us. And we, for licensing purposes, we actually have to go through a risk assessment and kind of really look at the behavior. Again, it's breaking down, but rather than that being a kind of a blanket made by Department of Human Services, this is putting it back on those agencies or employers to look, say, hey, date of incident, has there been any continued issues? Their disqualification period is lapsed or is no longer a disqualification. But as an employer, if you still are concerned about that, they could choose not to hire, but it wouldn't disqualify a person from moving forward to apply or be in those roles. I guess that's kind of what we landed on.
With that, Ms. Kaser, if an individual is not disqualified, that doesn't automatically mean they're going to become a foster parent, right?
Correct. Yep. We still have to recommend a license to
Right.
Department of Human Services. So there's still a process we go through in which we are recommending someone to be licensed for foster care.
Okay.
And just for foster care licensing's purpose, there's a lot more that goes into a foster care licensing assessment than just criminal background. So that's why somebody may not be disqualified, or we may be able to overlook any sort of crime on that background, but that doesn't mean that we're ultimately going to recommend a license.
Thank you so much, Ms. Kaser, Ms. Sherlock.
I do have one other question, John, about the second, the second point. So I'm trying to think of scenarios where somebody they'd get like a stayed sentence, but then the stay would be revoked and then they would be incarcerated because their sentence was revoked. So they could be eligible during that initial period where they're on probation or whatever. But then if it's revoked, then they would be incarcerated and then the 5 years would start to run, even though they had some of that 5 years had started before they went to prison, but the 5 years then would start to run after they were released.
Right. You could be on one trajectory and have that trajectory change. So if you've got a prison sentence stayed and it gets revoked and you go in, then you go to number 2 on this list that your 5 years does not start. Whatever time you had is erased and your 5 years does not start until the moment you're released from corrections.
Okay, thank you.
Yep. I want to make sure we got some time.
Mr. Chair,
Remedies too. Yes, please.
can I just briefly respond to that too?
Sure.
And this is speaking a little bit in generalities, because the situation that Representative Mueller pointed out certainly can happen and can arise under different circumstances. But again, just sort of in my experience as a criminal defense attorney, when people are on probation, if they're going to mess up because they're not doing the programming that they're supposed to do. They're not completing the treatment program. They're not doing the anger management classes. They're not making sort of the changes that probation is asking them to make. That typically happens in like the first year. So the folks that are on probation for a while and then come back with a probation violation, years later, I would say much more often than not. And this is again anecdotal and based on my experience, not data, but that's typically what I've seen is going to be a new crime that triggers a probation violation years into someone's probation period, which is also, if it's a serious enough crime, going to come with its own disqualification consideration. So I just point that out if that in case that helps alleviate some of that concern, Representative Mueller.
Thank you so much, Mr. Esme. That is helpful. I'm going to just go quickly through our analysis of the licensed family foster care. As we've heard from Ms. Gaither and Ms. Sherlock, we have some expertise in the subcommittee, and we looked at, so currently under the law, the licensed family foster care rules are a little bit different. They kind of separate from the regular Background Study Act, and that's pretty recent. And in fact, a lot of changes just went into effect in July of 2022. And the conclusion was that it was really kind of too early to really do anything with this, that we don't have enough time to determine the benefits of the changes. We don't have time to really identify what the problems might be. But it was really identified that what would be really helpful would be some additional for the department to maintain some data in a manner that would be easy to obtain in future years. The data that we've obtained from the department has been incredibly helpful, but it has been hard for the department to extract this data. And so there were some sort of basic recommendations for the department to start tracking with the new laws. So when the time comes, we can access that data to better further evaluate the changes and their impact on health and safety of individuals. We've made some of the bullets here. I'll have you kind of review those. And I see Inspector Modi's hand pop up pretty fast. Yes, Ms. Modi, please.
And I know I just want to be upfront. I know you probably know why. Very much looking at just, this is information that we would want to know. But I just wanted to share that because it's been specifically called out here from a DHS perspective, to be able to do this, there's going to be costs to that. And then we will be mindful of there's only a finite amount of things that can be done systems wise, and they have to be done in a particular order. And so that's also DHS will evaluate on that about how quickly, even if financial resources were made available to us, how quickly we could actually implement stuff. So I agree it does need to be tracked. We're looking at that, but just the realities of our systems, all this, how to do that. I just wanted to at least share that with the committee.
And I appreciate that, Inspector Modi. And I think we went into this having an understanding of that. And this is, I just think we tried to remove that and say that might be real, but this is the request.
And this helps to see what you all are thinking about what would be useful in the future too. So very appreciative of this, but I just kind of want to keep expectations a little realistic about what we're able to do, but this does help us say, what are others how are they looking at it? What would they be requesting?
I appreciate that. And then, so this just ends with the membership that helped provide this. And I want to make sure we have ample time to move on to remedies. Josh, are you going to present for remedies today?
I guess.
Unbeknownst to you.
Yeah.
Would you mind going over?
John, I'm here.
Oh, you're here. Okay. All right. I didn't see it come in. So are you able to see the remedies bullet points that we'll just put up, Lucas?
I'm not. Unfortunately, I got stuck in court, everybody. I apologize. So I am
No,
in my
understood.
car driving.
Josh, do you want to sort of work on this with Lucas and identify what the bullet points are, and then maybe the two of you can kind of do it together? Is that
Sure.
okay? I'll defer to you guys, and I appreciate you both.
All right. Sorry, I've got cell phones blowing up next to me too. So the first bucket that we looked at was the permanency list and what offenses we thought should be in the permanency list. I think there's ended up being some overlap between the two committees looking on this particular point. But some of the things we were looking at was sort of how overbroad the permanent disqualification list itself was. And we did some sort of digging into the background of how that list was put together. And we identified that sort of one of the issues was there are a number of offenses that need to be permanent disqualifications in order to be in compliance with certain federal laws that provide funding for important state programs. So that was the Adam Walsh Act and the Child Care Development Block Grant. And I think maybe there was one other. So the recommendations that we came up with were, first of all, to as much as we could, limit the list of permanent disqualifications to only those offenses that needed to be permanent in order to comply with federal law. And then we sort of anticipated that anything that was currently in the permanent list that didn't need to be there in order to comply with federal law would drop over to whichever sort of the biggest, longest disqualification category that the disqualification subcommittee came up with. Then beyond that, we looked also at sort of the types of jobs that these permanent disqualifications related to. And so we wanted to further remove permanent disqualifications altogether from a couple of different types of sort of employment that are already exist outside of the Adam Walsh Act. So we were anticipating not having permanent disqualifications at all if the person is going to work in substance use disorder related positions and facilities, and then in a group that we called family caretaker positions. So these are people who are applying essentially for funding from the state to be like a PCA or, a care giver to somebody who is already a family member, a disabled child or a disabled parent or something like that. And the kind of the rationale there was that the funding and sort of the state involvement in that doesn't actually change the person's level of access to the vulnerable person in the first place, since they're already related. And then for all other background studies that didn't need federal law compliance and didn't fall within those two categories, substance use disorder and family caretaker positions, a recommendation was that we adopt the 2008 task force's recommendation that permanent disqualifications be limited to murder, manslaughter, and felony criminal sexual conduct. That's the bulk of that, I think. Ms. Dawson, is there anything else that you think I might be missing under permanency?
The only thing that we did talk about, and we did not, the remedies subcommittee has added some extra meetings, and we actually met last night. And one of the things that we did not add, but need to add to that formal recommendation was that even if it's not required for, say, the Adam Walsh or the child care block grant, that an individual, even on a permanent disqualification, at some point would have the ability to show rehabilitation, because, you know, recognizing that people can change and people can be rehabilitated and can be contributing members of society. And so we did talk about that as well. That would fall more under the 245C.24 statute. But that is something, it's not on the paper, but we did talk about it, and we are planning to add it.
Yeah, thank you for that, Ms. Dawson. So that would, just to clarify, that would apply to this first bullet point, for background studies that do not need federal law compliance. That would be, you know, the murder, manslaughter, and felony criminal sexual conduct. Those folks, even though the length of the disqualification would be permanent, currently there's also a bar for those people to ask for a set aside of that permanent disqualification. We would recommend that we remove that bar so that somebody who actually can show rehabilitation and where the agency agrees that they have been rehabilitated could overcome the permanent disqualification. Any questions or discussions on the permanency issue that the subcommittee looked at? Yes, Inspector Modi.
I don't have actually a question, but I noticed this is a good break. I am going to have to step out of this meeting, but just wanted to let you all know that. But Autumn Baum, our legislative director for OIG, is here. So I just wanted to share that with you. So if you notice, I'm gone. So sorry to interrupt, but.
Thank you. Okay, the next big issue that our subcommittee looked at was the current preponderance of the evidence standard that is used as the basis for a disqualification, even in the absence of a conviction. And kind of the main concern that we had going into this, there were a few, but one is that it does create situations where people who are not only presumed innocent under the law, but may very well be actually innocent of the conduct, end up getting disqualified for it nonetheless. We also are sort of concerned about sort of the amount of sort of labor that goes into making these preponderance of the evidence determinations and then litigating them when they do get litigated. This is one of the issues that can go all the way up to a contested hearing, DHS judge or an administrative law judge, where we essentially have a second mini trial, sort of shadow criminal justice system about whether someone should be disqualified or not. And the third just being that it is really uncommon. We did a pretty thorough review of other state laws, looking to see if any other states sort of related statutory schemes doing background checks for vulnerable people operated similarly. And as far as we could tell, Minnesota was the only state that disqualified people on evidence less than a conviction. So our recommendation was simply to remove the preponderance of the evidence standard so that disqualifications would not be based on that. They would be based on convictions and stays of adjudication. So a stay of adjudication, I think we all know, but just for the record, is a fairly common disposition in criminal court where somebody pleads guilty or in some narrow circumstances is found guilty, but the judge puts them on probation without pronouncing that guilt and without entering a conviction against that person. So they're sort of on probation while they're in this sort of legal twilight zone where they're not actually convicted. And then at the end of the probation period, the case is dismissed. So even though that's not a conviction, we felt that it was certainly enough proof, given that there was a guilty plea offered, to be certain that the behavior that would trigger the disqualifying event occurred. So that's how we ended up with convictions and stays of adjudication. We also looked at sort of a related issue for disqualifications based not on criminal charges, but on findings of serious or recurring maltreatment of children or vulnerable adults. Actually, if I may, I might just hand off that issue to Ms. Dawson to explain our recommendations there. It's a little bit more her area of expertise.
Sure. Thank you. And really quick, if I could go back to the preponderance of the evidence, one thing that we did learn in our research was that under the current, I guess, guidance at the Department of Human Services is that they are, at this point in time, making disqualification really only where someone has been formally charged, not where a charge has been declined. But that's just simply a current internal policy. And so I think one of our concerns was wanting to make sure that something is solidified so that individuals coming before the Department of Human Services on a disqualification can know they're being treated the same regardless of the administration that is in at that point in time. And then the other piece to that was that would then bring in people who maybe receive the benefit of a continuance for dismissal. And the whole point of a continuance for dismissal is that someone is actually not pleading guilty. And we're concerned the Department of Human Services may not all know what's going on. But the whole point of the continuance for dismissal in the criminal system is the rehabilitation. And then the person has the ability that their case is dismissed after that point in time. And so, I think from our perspective, really the criminal justice system, the judge, the prosecutor, the defense attorney are really all in the best position to make those determinations and are really making those determinations and those agreements based on perhaps additional facts that may be in the case that may not be provided to the Department of Human Services. And really to allow that person to not have the matter on their record. That's the whole goal of it. That's the whole point. And so it's counterintuitive then to use those in making a disqualification determination. So that was just an addition there. Then as to maltreatment, that was a very important issue. Definitely that is somebody in our group who has a lived experience with that. And some concerns that we noted is that for the other conduct, the burden of proof is higher. So, for example, most of the disqualifying events, the burden of proof in the criminal justice system is proof beyond a reasonable doubt. The other one that is there is involuntary terminations of parental rights are another disqualifying event. But in those, the standard is clear and convincing evidence, whereas maltreatment are made and determined based on a preponderance of the evidence. So we had some concerns that was being used at a lower standard versus the higher ones where we're really looking at conviction or admission to those offenses. And then, so that was one concern that we had. Another concern we noted is that so it's not only serious, but also reoccurring maltreatment. And that currently, back up here, the way that a case can come to the attention of child protection is either through what's called a family assessment or through an investigation. And at the end of an investigation, a maltreatment determination is made. For family assessments, that is not the case. The whole point of the family assessment is to essentially get some eyes on the family, to offer services, to help with rehabilitation, and to really look at what services can benefit this family to move them forward. Is it therapy? Is it parenting education? Is it treatment? Something along those lines. We're really looking at more of that rehabilitative approach. And the problem is that family assessments are not appealable. So they come in, child protection meets with the family, they determine if services are appropriate, and then the family either cooperates or they may not even have to. Maybe no services are determined to be necessary. And so they're not appealable, but yet family assessments are used when analyzing a disqualification for reoccurring. And so that was definitely a concern for our group. And then this is just something that I have definitely noticed as I practice and do quite a few maltreatments, is that the appeal process can be somewhat, I think, confusing. And unfortunately, I've had a number of people who will come meet with me who did not understand what needs to happen. And our goal as the Remedies Subcommittee was simply that when we're looking at the loss of somebody's job, we're looking at their inability to provide for their family, we really want to make sure that there is due process. And so just noting that concern, what our recommendations really are that first of all, that family assessments would not be used in determining whether maltreatment is reoccurring, that it has to be an actual maltreatment finding. Second of all, that an individual on a maltreatment finding would be entitled to both a correctness review, so they're entitled to the request for reconsideration, and ultimately a hearing on the underlying allegation. And then thirdly, that at that, it would have to be proven by clear and convincing evidence, just understanding that the lower level was preponderance of the evidence. I think for our subcommittee, the really big and important ones to us are for sure that family assessments are not used, and that individual is entitled to not just a review for risk of harm, but also that correctness of whether the determination is actually correct as to whether maltreatment was either serious or reoccurring. I think I covered it all. I guess, Josh, if you could let me know if I missed something.
I think that was thorough, and so we had a couple hands up. So I think Inspector Modi.
Yes, because I do need to leave in a minute. Couple of things I just wanted to share is from a DHS OIG perspective, we don't use family assessments for reoccurring. It needs to be a substantiated maltreatment. So and a one-off or separately, if that is a process or something that people believe that is happening, I'm going to want to know about that to look at our process, because it does need to be unsubstantiated maltreatment. So I just wanted to put that out there. And then I just wanted to note that a significant amount of maltreatment determinations are handled actually at the county level. Like DHS is not the only entity that handles maltreatment determinations, and so wouldn't necessarily have been a part of that whole process on it. So I'm just curious if the counties had, or county representatives had an opportunity to look at that, as well as there are other state agencies that do that. So just wanted to flag that kind of at this point, to be that DHS is not the only entity that is making those maltreatment determinations. On that, we are just looking at the final disposition of that, whether it's been upheld or not. So I just wanted to at least make those 2 points before I needed to step out of the meeting.
Excuse me, Chair. Inspector Moody, I would like to address you before you leave. You actually have me shaking here. That is exactly what happened to me. Your first point that you made, that is not what's happening. It was a family assessment that was used as being considered reoccurring.
So
that's exactly what happened to me.
Okay, so at that point, I can happy to look into it on that, and maybe reach out to you separately, Ms. Williamson, on that. And so I will take a look to see, and I do an additional review, because that was not my understanding. So I can happily to reach out to you separately.
Thank you, Inspector Modi, and I have all of the documentation.
Okay, thank you.
I also I wonder if that's another one of those areas where current, like the current agency policy is something that could be different from other periods of time. And so it might be something where, maybe our recommendation is actually in line with what DHS is already doing, but it would be something that we would want to codify to protect going forward. We've seen that sort of come up in a couple different areas too. Was also a hand, Michelle.
Yes, thank you. I just wanted to add that although certainly with 87 different counties in Minnesota, there is a possibility that some counties do things differently. But generally, at least according to statute, family assessments are used and offered to families if there isn't an imminent risk of harm and there isn't recurring maltreatment, and the families participate voluntarily. Not saying that I wouldn't also share a concern with regard to some of the appealability issues, but just clarifying when family assessments are used.
Thank you, Michelle. Ms. Dawson, is that something that you want to respond to, or?
Well, I think I would just add, definitely I think as we're looking at this, we're not just looking at DHS, as was highlighted. There are 87 counties that may be involved, and that may, I think the goal is really just to codify it. In some ways ensure that everybody, that people know what's required and they know what can be used. But yeah, no, I definitely agree with family assessments, and that's why part of the recommendation is that they should not be used in the definition of a recurring maltreatment, because the whole goal is to offer services and to help the family move forward. It's not to make that maltreatment determination. So I think all very good comments, and definitely understanding the process and just having it codified is really the goal.
All right, anyone else have anything they want to discuss on the preponderance of the evidence issue? Hearing none, then we can move on. The last sort of big kind of bucket of issues that we looked at was related to sort of the process of going through the background check study itself, and then more specifically, requesting reconsideration once the person is disqualified. And so kind of this section ended up, with a number of recommendations that are sort of, I think, generally geared at making that process more fair and or more easy to go through. So some of the things we looked at there, just kind of going through these bullet points. One concern we had was that it didn't seem to us that the agency had quite enough discretion when issuing set-asides to people who really have very limited contact with vulnerable people, because they're in non-direct care positions. So things like, building maintenance or food services, those types of things. Currently, it seemed to us that at least under the statute treats direct care and non-direct care people the same. Now, I do know from experience that one of the questions that is asked on the set-aside does give an opportunity for people to talk about kind of the level of supervision that they may have, and the level of access that they may have to vulnerable people. So it looks like this is one of those areas where the DHS is currently looking at that to some degree, but it's not a statutory factor. And I think our recommendation here, it's a little unclear from the bullet point, but from my recollection, our recommendation is essentially that factor be codified in the list of factors. Does that sound right to you, Ms. Dawson? Okay. Other things Another idea for making the process more user-friendly is to make standard forms more readily available. I think on this one currently, it seems like DHS does have a standard form that gets mailed out to people. I think our recommendation on this one was more that standard form be more easily accessible online, or prior to, for folks to obtain prior to background studies, look at it ahead of time, that kind of thing. Other problems that we were reviewing, we thought that, one problem is that the current reconsideration process is all done by paperwork, by submitting, written requests and written arguments. I know that is not something that is accessible or easy for a lot of people to do, and sort of to make their best case in writing is a particular skill that not everyone has the opportunity to develop. So one of our recommendations would be that there be a process created for people to seek the set aside on more like an interview, sort of oral sort of meeting. Kind of the model we were thinking of is sort of like a hearing officer, for like a traffic ticket, that kind of thing, where you can actually meet with somebody and make your case. Will, was there anything above that I should touch on, or you think we should just go to the next bullet point?
Mr.
Oh, I
Esme,
think that's
Go ahead. I apologize. I'm sorry, Ms. Dawson. Go ahead.
Oh, no, I thought you covered it, but I can't tell if there's a question.
Yeah, I think that's the substantial February recommendations, Mr. Esme, and here are the current recommendations that the group's worked on.
Okay, I see. So these so that, just for context, that last list of bullet points was more things that we were considering as problematic, and this section of our working document is more the specific recommendations. So the first one was related to the timing of the appeal. Currently under statute, it's 15 to 30 days for DHS to respond. I'm sorry, for the applicant to respond after getting notice that they've been disqualified. 15 days in particular is often really hard for folks to do. So our first recommendation was that it just be standardized at 30 days. We also thought that it would be very helpful if we could codify that if the person is able to give a sort of a good cause explanation for why their request for reconsideration was not timely. I was sick, I couldn't afford to travel to get the documents, something like that, that DHS would have the discretion to extend that. That's another area where it's my understanding that DHS already is kind of flexible with that for people. But again, it's a thing where we would want to codify sort of the current practices to make sure that, the future administrations would behave the same as the current administration. We had a suggestion that we have either personal service or certified mail for the notice of the disqualification. Anecdotally, both myself and Ms. Dawson have had clients who just simply didn't get the normal mail. And then this is more maybe aspirational, but this current system is very archaic. It's all paperwork done through snail mail. It would be great if DHS could look into building a web portal and move this reconsideration process online. We also looked at another concern is currently the applicant for the set aside is responsible for obtaining police reports, and that's something that is time consuming. can be difficult to do, may involve traveling to different parts of the state, and seems to be, somewhat duplicative, because it is apparent that DHS also has their own access to these police reports. Anecdotally, I know that they end up having them as a part of the discovery that they provide if you end up litigating an issue far enough to the contested hearing. So to us, it doesn't seem to make sense to put that sort of administrative burden and barrier on the individual. We would change it so that it's DHS's responsibility to get the police reports and provide them to the applicant. And furthermore, that the 30-day window for requesting reconsideration wouldn't actually start until DHS provides the police reports. And kind of the idea there was we didn't want to create something that would delay the initial disqualification decision by creating a sort of an extra step for DHS to do. So kind of the compromise would be that DHS could issue the disqualification while working on getting the police reports, and then the timing for the reconsideration request wouldn't happen until the police reports were provided to the applicant. The next bullet point really only comes into play if our previous recommendation that preponderance of the evidence determinations be eliminated doesn't come to fruition. So kind of if we go forward with a scheme in which preponderance of the evidence determinations still create disqualifications, under that circumstance, we would recommend that we remove language in the statute that currently creates a sort of a waiver of your right to challenge the preponderance of the evidence determination if you don't do so the very first time that you've been disqualified based on that preponderance of the evidence determination. And so this creates a situation where, someone might apply for a job, not even knowing that they're going to be disqualified because, maybe they had a charge that got dismissed and no one informed them that it may still have collateral consequences. They don't get the job because they're disqualified, but for whatever reason, they don't challenge it at that time. Maybe it wasn't a job that they cared about enough to go through a bunch of hoops, in order to litigate whether they should be disqualified from it or not. If they don't challenge it then the agency's determination that there's a preponderance of the evidence becomes final and their ability to challenge it is waived. And then years later, they come back. They're further on in their career, they've completed their education, but they're still in a position where they're applying for a job that creates a disqualification. And now, lo and behold, they learn that their failure to challenge it years prior has locked them out of that position. That whole scenario happens a lot and seems profoundly unfair. So our recommendation is that there's just no waiver. You can, until the time that the preponderance of the evidence determination has been determined finally by a contested hearing, your ability to challenge it would remain. Another issue we looked at was the turnaround time from DHS on requests for reconsideration. The statute lays out some time periods, 15 days if it's a risk of harm analysis, so just a set aside, 30 days if the challenge is to the correctness of the determination, so that's where the preponderance of the evidence challenges would go, and 45 if the person requesting reconsideration is asking the agency to look at both issues. What the agency seems to be doing in our experience right now is oftentimes, just because of the workload, they cannot meet these. So what they seem to be doing is telling people that they need more time. So they technically respond, but the response is just to say, hey, we're working on it, we need more time. But then currently what the agency usually does in those situations is allow people to work while they continue to work on the request for reconsideration. And sometimes that can go for months or even a year or more. And that actually sort of, again, seemed like a pretty good compromise. So we would just want to codify that that's what should happen in that circumstance. But then we also wanted to hopefully require that a final decision could happen within 6 months. Part of our hope here is that getting rid of the preponderance of the evidence workload for the agency might help expedite the smaller and hopefully simpler cases that they do have to look at. Another issue we looked at was sort of a long-standing difficulty getting what people often call a traveling set aside. But the basic idea here is to not make people go through multiple background checks for the same thing, and to make it easier for the agency to grant a set aside that would apply going forward to a set of similar jobs. I know that's something that the agency has been wanting to do for a long time, but that there are sort of technical reasons why that hasn't been easy to happen. Our basic recommendation here is to sort of work with the agency to come up with sort of a strategy for making that happen, and including sort of any legislative changes that would make it easier for the agency to do that. I think we talked about the accessibility, communication, and writing part, so I won't go over that again. We talked about the community resources part, won't go over that again. Oh, no, I will. So currently in the paperwork that the agency sends to individuals who have been disqualified, there is a really helpful section that directs them to places where they can get legal aid. So that might be actually legal aid itself, Volunteer Lawyers Network, some other agencies that might be able to provide low cost or even free legal services. And again, this is an issue where we would just want to codify that should remain the practice going forward. This next bullet point, stay of adjudication versus stay of imposition disqualification length. This is an issue that arises because when someone has a stay of adjudication, the case ends up getting dismissed, but doesn't have the level of the conviction changed in any way. Where with a stay of imposition, the person may be charged with say a felony, get a stay of imposition, successfully complete their probation period, and the resulting record shows that the felony level charge ends up with a misdemeanor level conviction. This creates sort of an odd tension because a stay of adjudication is in almost all other circumstances objectively better than a stay of imposition. A stay of adjudication has no finding of guilt and ends up with the case being dismissed, whereas stay of imposition has a finding of guilt and merely ends up with the level of the offense being reduced from a felony to a misdemeanor. But because the way the DHS background statute looks at that final disposition, we have this tension where a stay of adjudication can leave the longer disqualification period, where a stay of imposition actually shortens the disqualification period. And that doesn't make a ton of sense. And so our recommendation would be that when someone has a disqualification based on a stay of adjudication, that they get the shortest disqualification period that the disqualification subcommittee ends up deciding upon. And then the risk of harm factors, we touched on this at the top too. This is just codifying that DHS should consider the level of supervision and frequency and access to vulnerable people when deciding whether to grant a set aside. We had another suggestion was of trying to find ways to improve sort of the accountability of the agency in making these decisions. And one suggestion that we came up with was looking at sort of other similar statutory schemes. And we thought about an applicant winning attorney's fees and possibly even lost employment if they end up fully litigating something through a contested case hearing and winning. So ultimately having a administrative or a DHS judge finding in favor of the applicant and finding that the agency wrongly disqualified them. And I think in particular, the attorney's fees part could be really helpful because it serves sort of two purposes. Create some accountability on the part of the agency, but also improves access on the part of applicants to attorneys who would be able to more easily take on these cases for people who can't afford attorney's fees up front. And then the last thing was a suggestion that came in the last couple weeks from outside of the committee, and I don't remember who made it. Outside of the subcommittee, I think it was one of the other committee members. I mean, maybe Gina can remind me, but it was to a mechanism to try to reduce racial disparities in the set-aside process by creating a sort of a blind application process. So people's names, income levels, addresses, things that could trigger sort of implicit bias would be sort of removed from the materials that DHS is reviewing when deciding to grant a set-aside. And that's not on this document, but it was something that just came up that we've been talking about in our last meeting. I think that's everything. Ms. Dawson, is there anything you want to add?
No, I think you covered it all very thoroughly. So thank you very much.
Anything anyone
Thank
want to
you,
talk
both
about?
of you.
I'll turn it back to you, Chair Geffen.
Thank you so much, Mr. Esme. We're at about 11:30, and we lost a couple of people, I think. Mr. Vogel, can you kind of go through next steps as we move forward now that we have these recommendations and timing a little bit? Because I know that we are starting to get short on time, both today and with the whole task force.
Certainly, Mr. Chair. The deadline I'm just going to keep harping on is December 16th. That's when the statute that enabled the task force requires that the final report be delivered. And we presently have three of these meetings scheduled between now and then. So one on the 16th itself, sort of going backwards, one on this December 2nd, and one on November 18th. And so I guess I'd just like to urge the members to think of the 16th as not a day to get substantive work done. Like if for example, Mr. Chair, you anticipated holding a vote that day, I'd strongly suggest it be a vote approving the final text of a report whose substance and even like most of the text has already been agreed upon by the membership, just because there won't necessarily be time to incorporate changes and approve changes after that meeting. And so thinking of the workflow backwards from the 16th, then there are the meetings on the 18th and December 2nd. I think my suggestion would be that the members try to reach a consensus on the substance of what they'd like to be in the report by the 18th, and try to reach consensus on the text to embody that substance by the 2nd. This is a very tight time frame, so I'm just sort of like suggesting these specific dates to sort of point out how limited the time is. Also, Mr. Chair, as a reminder, we do have sort of a scheduling issue if additional meetings are necessary to get this work done. Next Friday is Veterans Day, and the 25th of November, Friday the 25th, is the day after Thanksgiving. So both of those days are holidays, and staff availability will be an issue. So any additional November meetings we'd need to schedule not at this regular time, which is kind of problematic, but like, please reach out to me and let me know if that's something you'd like to pursue. We would, just in terms of staff availability, I don't know about member availability, we don't have a meeting scheduled for December 9th, which is the Friday between the 2nd and the 16th. So if that's something you'd like to get on the radar, that at least would be very doable from a staff perspective, but I don't know what you're envisioning, Mr. Chair.
You know, I don't think I have a vision. So I think at this point, what I would prefer to do is work hard on the next date and see where we're at before we add the 2nd. So our next is in 2 weeks, the 18th. On that day, we're going to vote. We're going to vote. And Mr. Vogel, I'd like you to kind of commemorate this and put it to an email to the entire group that we have the recommendations, include the recommendations as provided by remedies and disqualifications to the group, and that we're going to vote on it. And the goal probably that day is to see where we're at, and hopefully we have some consensus. I think we should outline that what we're voting on will be under a simple majority. Can have a discussion maybe next week if we have significant dissent about what that looks like in a report. Be included who will be responsible for identifying those issues. But I think our focus should be on the 18th right now and getting things voted on. They're going to be the ones that have already been distributed. Certainly open up to questions a little bit then too, but that I think we need to get past that vote to get to the next round of writing, make it clear who's going to do the writing, how that writing is going to be submitted to the broad membership, and when, getting them time to vet it. So that's the plan. Mr. Page, good to see you, and please.
Thank you, Mr. Chair. Good to see you as well. I apologize for being late today. If there are those of us who end up voting against the report, which I'm not saying that I am, but just contemplating that, is a minority report something that is contemplated? And if so, when would that be? Would that have the same deadline, or what would be the steps for that? And this is all hypothetical.
So I think, and we can talk to Mr. Vogel and others on this too. I think my vision of that is, yes. I mean, I think we should probably vote actually on what to do with minority reports or any dissents, but I think it makes sense to open that up. I think we need to do a little bit of work on exactly what options we're going to have, because it does still need to be on the same timeline. Yeah, Ms. Williamson.
Thank you. My only suggestion would be, with Mr. Vogel mentioning December 9th as being an option, I think that we should schedule that just so that we have that additional meeting date if we need it, especially considering the concern Mr. Page just brought, and just giving us just an additional meeting time if need be.
Okay, I'll accept that. Is it, and what was the date, Mr. Vogel, that you can add? I already forgot.
Just Friday, December 9th at this regular time would work from a staff standpoint, Mr. Chair.
Let's add that with the focus
Okay.
on, let's do our vote next week, have a discussion about what we're going to do with those who don't want to or can't, or whatever the issue is on a minority report, and then figure out how to incorporate that and utilize that next session for that. That sound like a plan? All right, I think we're over time, and with that, we're going to adjourn today's meeting. Mr. Vogel, we're sort of throwing some stuff on you to get out to us, but I want to thank everybody for their time today and input, and let's just keep moving forward.